It's interesting to exist in a moment in history when the outcome is so unforeseen and unforeseeable.
Having that overturned all in one fell swoop is a remarkable moment in the court's history.
If the court is going to bind itself to quote unquote history and traditions in interpreting any kind of fundamental right, that throws a lot of other rights into question.
The Supreme Court is currently experiencing or is the locus of a lot of controversy, much of it self-inflicted.
I mean, as an attorney, I think I always took pride in knowing that we have all of these checks and balances in our legal system, and it just seems like those checks and balances aren't quite what they used to be.
The 1973 and 1992 courts were wrong by inferring a right to kill an unborn child without actually having that language in the Constitution.
You can't just count up the D's and the R's on the bench and predict the outcome, right? And that's been true ever since 1938 in our nation's history until now.
Americans, I think, for the first time in our history, perceive a court that is split politically, ideologically, down the middle.
Will the right to marriage equality be something that is vulnerable? Will the right to birth control in all its forms be vulnerable?
On May 2nd, Politico published a leaked draft of the Supreme Court decision in the Dobbs v. Jackson's Women's Health Organization. The central quote in the 98-page draft is 5 pages in. We hold that Roe and Casey must be overruled. Many abortion providers immediately began preparing for a world without Roe. Over a month and a half after the historic leak, Roe v. Wade and Planned Parenthood versus Casey were overturned by the Dobbs decision. What many saw as a constitutional right to abortion was now fundamentally altered.
As the court reconvenes for its next term on Monday, October 3rd, questions about its future have loomed, especially in the wake of protests over the Dobbs ruling and discussions over its current 6-3 conservative majority. So, what does the future of the Supreme Court hold? Well, over the course of this special WRHU broadcast, you will hear from attorneys, journalists, organization leaders on Long Island and across the country who will provide their thoughts on recent Supreme Court decisions, as well as where the institution is heading. I'm Ryan Pagano.
I'm Michael Richardson.
And I'm Lindsay Hill. The following material may be sensitive to some. Listener discretion is advised. Any thoughts or opinions expressed during this broadcast do not reflect those of WRHU, Hofstra University, and its Board of Trustees. All opposing opinions can be sent to programming@wrhu.org.
Having that overturned all in one fell swoop is a remarkable moment in the court's history.
Let us begin by focusing on what many see as the biggest decision to come out of the Supreme Court last term, the overturning of the 1973 case Roe v. Wade. WRHU reporter Yao Bonsu had a chance to speak with SCOTUS blog author and Fox 5 DC anchor Katie Barlow on the impact of the Dobbs decision.
Obviously, it was a huge earthquake to overturn a near 50-year precedent in Roe v. Wade. It was approaching, 50 years in the books, so to speak, the constitutional protection for a person's right to choose to have an abortion. So having that overturned all in one fell swoop is a remarkable moment in the court's history. 5 justices voted to outright overturn Roe v. Wade and eviscerate the right to choose to have an abortion. 4 justices were not willing to go that far, including the court's 3 liberal justices, Breyer, Kagan, and Sotomayor, joined by Chief Justice Roberts, who was willing to uphold Mississippi's ban on abortion after 15 weeks, but not go so far as to overturn Roe v. Wade. But what I think we have seen, Justice Kavanaugh wrote in his concurrence, this will finally put the pen down for us on abortion and leave it up to the states to decide, and the state legislatures and the elected officials. And that hasn't happened yet. In fact, there are every week on In the Courts, I'm covering, a different iteration of a state court battle over a law that has passed in the state, and it's playing out in state courts right now, not in state legislatures, or it's playing out in both, rather. But we're also starting to see it at the federal level. The Department of Justice sued Idaho over their abortion law, arguing that it violates a law that is supposed to provide protection for emergency health care, regardless of your ability to pay. And I suspect that's not the only type of lawsuit that we'll see. But this issue didn't quiet after Dobbs. And so I think that is one of the results of overturning something that there had been reliance on for 50 years. And should the court make similar decisions, overturning similar precedents, I think we'll see, a similar track. But that's not to say that's something in the near future. I will say the court has agreed to take up a pair of affirmative action cases where it at least appears that the court is interested in speaking on the topic of affirmative action. They have something else, something new, something different to say than the current lay of the legal land, which the court has said that the consideration of race in the admissions process is allowed as a part of a holistic review. I wouldn't imagine the court would agree to take up another case unless they had something different to say on the matter, but we'll find out next term.
Cynthia Grande is the founding attorney at Grande Law Firm. Her firm focuses on immigration law, helping clients who have recently arrived in the United States or have lived here for years. She discusses how the recent Dobbs decision impacted her practice.
I think what we've been doing is focusing on working and moving our clients' cases, as quickly as possible because we just don't know what changes are coming. So it's important that we're able to move our clients' cases forward so that we can get the results that we're looking for as quickly as possible because we can't plan. We don't know what's going to happen, the next election, the next couple of years. We've always been passionate about the work that we do, but it's definitely pushed us to be more zealous than ever in our advocacy for our clients' rights.
Emily Galvin Almanza is the co-founder and executive director of Partners for Justice, who also worked as a public defender in the Bronx. She believes we could see more pregnancy-related prosecutions as a result of the Dobbs decision.
I feel like we're about to see a whole bunch of pregnancy-related prosecutions that are based on junk science or on really, really bad policing and really unconstitutional policing of, I expect, particularly non-white female-presenting people.
Will the right to marriage equality be something that is vulnerable? Will the right to birth control in all its forms be vulnerable? Those questions are legitimate ones that we will be facing possibly in the future.
Who we just heard is Sonia Osorio, the president of the National Organization for Women, New York City. We spoke to her about her organization's response to the overturning of Roe v. Wade and whether New Yorkers should be concerned over abortion access.
New York is safe. We have had great legislators, from Governor Cuomo to Kathy Hochul, who've really, really done a lot to ensure that not only it is legal, but that it's accessible and that the public knows about that. I mean, Kathy Hochul has passed in a short amount of time funding to bolster the clinics that are here. She's passed legislation to ensure that the medical providers who are giving care to those people who are coming from outside of New York are legally protected. So there is a lot. Now we have set up a Be a Friend in NYC, which will expand throughout the state so that our members can provide the support and the guidance that someone who's coming to New York who doesn't know New York will have, whether that means advice beforehand on how to navigate cities across the state or someone to help escort them to a clinic. We're setting that up so that people coming to New York will be able to navigate our cities and get the care that they need before they leave.
In the wake of the Dobbs decision, various states across America have made efforts to legalize abortion or ban it outright. On August 2nd, Kansas voters sided 59 to 41% in favor of maintaining abortion protections in the state. Founder and president of Public Rights Project, Jill Habig, discussed how state and local governments factor into Supreme Court decisions.
I think state and local governments have tremendous power here, in part because while the Dobbs decision decided for now the federal constitution and removed a federal constitutional right from women to access reproductive health care, it did not decide what any individual state can make as their policy. So if a specific state constitution protects the right to abortion, then women and anyone else who can get pregnant in that state and anyone who is surrounding that state who could travel to that state can still access abortion. If a state legislature or a governor wants to prioritize abortion access, they can pass laws in their state to advance abortion access. And so the Supreme Court made a huge decision that certainly affects all of us across the country now by removing a federal right. But what that does is actually now push the fight into each state, state by state, to decide the future of reproductive rights.
Many against the Dobbs decision cited the doctrine of stare decisis, Latin for let the decision stand. Stare decisis is a legal term whereby most cases are decided according to precedent. Activists in favor of Roe believe that precedent was violated.
The 1973 and 1992 courts were wrong by inferring a right to kill an unborn child without actually having that language in the Constitution.
Author and founder of the Constitution Study, Paul Engel, talks about stare decisis and his belief the court made the correct decision in June of this year.
Well, like many things, it's good when it's put in its proper place, when it has its proper effect. The idea of what did other people say about as both a looking for an alternate point of view or as a starting point for where you're going is good. But the supreme law of the land, Article 6, Clause 2, lists three things as the supreme law of the land: the Constitution, the laws of the United States made pursuant to the Constitution, and treaties which are made under the authority of the United States, which is established by the Constitution. Nowhere in there is the opinion of a court considered the supreme law of the land. In fact, it's not even law. Article 1, Section 1, Clause 1 of the Constitution says all legislative, all lawmaking power resides in Congress, not in the courts. When there is a conflict between a precedent and the Constitution or the written laws of the United States, the Constitution must win. The written laws must win. If not, we are not a republic anymore because we're not making the laws. 9 men and women in black robes are making all the laws, and we are just dancing to the oligarch's strings.
For many years, there have been calls for reform at the Supreme Court. One of the ideas frequently floated around is the idea of expanding the number of seats, as there is currently no set limit on how many justices can sit on the Supreme Court. In the 1930s, President Franklin Roosevelt came under scrutiny for his plan to add another justice for every justice over the age of 70, which would have tilted the court towards his ideology. Lawyer and host of the Opening Arguments podcast, Andrew Torres, discusses his thoughts on court expansion.
You would need to pass a law, a new Judiciary Act, that would create additional seats and then fill those seats. That is rightfully viewed as a provocative option, but that may be the only option we have if the Supreme Court continues on its current path. So I did a public interview on this very question in 2016, pre-Donald Trump, and I said, with still a conservative Supreme Court, and I said, that court is sometimes derisively referred to as court packing as opposed to court expansion, and I said, will never happen. It's a terrible idea, and that's something I was wrong about. We watched the Supreme Court, the federal judiciary, get weaponized. And at some point, you do have to fight back.
The process for confirming Supreme Court justices has also come under scrutiny, especially in the wake of former President Trump's nomination of Amy Coney Barrett days before the 2020 election. Founding attorney at Grande law firm, Cynthia Grande, wants for that process to change.
The way that we confirm justices to the Supreme Court, that there's a standard that doesn't depend on which political party is in control of the Senate. I think that would really go a long way if we could have a consistent process that really has the attention on our entire population, not just certain demographics. I think that could go a long way, and I think it used to be that way for a while.
Emily Galvin Amanza mentions how if the court was headed by a liberal-leaning majority, there would be similar outrage.
Yes, if the shoe was on the other foot, I think we would be absolutely seeing the same amount of outrage. I think there is a real question as to whether such extremity is possible with the shoe on the other foot. I mean, I think the running gag of our political discourse is that the more liberal or progressive side doesn't do such extreme things and doesn't necessarily play the game with the same ferocity as conservatives. So I think there's a real question of whether this would happen with the shoe on the other foot, but we're not in that position. So all we have before us is a court that was brought on board to eradicate an individual right and has succeeded in doing so.
Transitioning towards what the future may hold for the Supreme Court, Hofstra Law professor James Sample had this to say.
And I think that we are at a stage where we have a supermajority on the Supreme Court, and a good portion of that supermajority is more or less on track to impose a near theocracy on our society under the guise of religious freedom, but actually using religious freedom, which we should all favor as a concept, as a weapon to discriminate against a range of individuals, including, and most particularly perhaps women and same-sex couples.
Katie Barlow also shares her thoughts on what Americans could expect in the future.
Well, I think if you were to ask the justices, the sentence would be the work of the Supreme Court right now is business as usual. They've just ushered in, a new set of clerks. They have welcomed in a brand new Justice Ketanji Brown Jackson. And so I think if you were to ask them, it's business as usual. I think you might get a different answer if you ask any politician anywhere in America, or if you ask the American public at large. And so I think what will be interesting to watch in the coming year, where we don't have a Dobbs case on the agenda, but we do have some pretty big blockbusters, how the American public responds to the court continuing to do its work, business as usual, also in an election year.
Journalist, CEO, and president of Agua Media, Rick Sanchez, believes the court has become political in a divided American society.
Americans, I think, for the first time in our history, perceive a court that is split politically, ideologically, down the middle, because they're not looking at the law. They're looking at politics, and it's as clear as a bell to anybody who sees it. I think as long as we are a divided nation politically, seriously divided, almost to the point of it being critically divided, as long as our politics are so divisive, I think the Supreme Court will only become more divisive.
No matter what the ideologies of the justices may be, Paul Engel feels the court should not be swayed by public opinion.
Well, anything's possible in the future. I believe it was Justice Sotomayor was at a judicial conference a month or two ago, and she had a very interesting phrase. She says, if the court doesn't listen to public opinion, it becomes illegitimate. I'm paraphrasing greatly, obviously, which is exactly the opposite of what our framers set up. The reason we do not elect judges, the reason the judge serves during their good behavior is because we didn't want them being another political branch. We didn't want them concerned with public opinion. We wanted them concerned with the law. Congress is concerned with public opinion, not the judiciary. If all it takes to change our laws is a loud enough group of people, a loud minority to influence the judges, then we end up in oligarchy, not a republic. Look at what happened when Dobbs was finally announced. Yes, people protested. I have no problems with protesting as long as it's peaceful. But that's not all that happened. We had attacks on churches, on pro-life organizations. There was, some of it was simple graffiti. Some of it involved firebombing and threats. If that's all it takes is mob rule, we are no longer a republic. We are effectively a democracy, where all it takes is enough people to influence not the entire country, but to influence the people making laws or applying laws, to ignore what the law says because public opinion is this way.
Covering the law for his entire career, Andrew Torres shudders to think of a Supreme Court that is more political than not.
This is deeply personal for me. It is my profession, it is my passion, it is my life's work. And the idea that people think and have a justified basis for believing that it's all sort of politically up for grabs is really terrifying to me. So I think it will come to a head, right? I think that there must be some reckoning in the way that Roosevelt threatened to pack the court and change the trajectory. Something has to be done. I do not believe people will sit by and let us go into another 40 years of the Lochner era of a tiny minority under preventing legislation and undoing prior decisions that protect the most vulnerable in society. I just don't see that happen.
Individuals such as Galvin Amanza and Habig feel that the way the court is heading is not sustainable and are concerned about more cases being overturned.
But I don't think it's sustainable because when you have an institution with so much authority, whose views are so far out of step with the people on whose lives they are ruling, you're going to get rulings that the vast majority of Americans hate. And when you have the vast majority of Americans furious with the highest authority in their legal system, I think it tears at the very fabric of our society. I think it has crippled the legitimacy of an institution. I think it's infuriating a majority of Americans. No, it's not sustainable. Somebody is going to have to do something, or else the will of the people is being utterly set aside and oppressed by a tiny minority of very powerful folks.
If the court is going to bind itself to quote unquote history and traditions in interpreting any kind of fundamental right, that throws a lot of other rights into question, most notably LGBT rights and Obergefell. Also, even cases further back like Lawrence v. Texas that were about not just marriage equality, but also same-sex couples' right to privacy in their own intimacy with each other as couples in their consensual relationships. Things like right to contraception would also be potentially called into question. So I am very concerned about this trajectory that the court is heading down and the way that the court has really lurched to the right with the most recent justices added to the court.
The Supreme Court will begin hearing cases for the 2022-23 term on Monday. Among them, a pair of cases that could lead to an overturn of the 2003 decision on Grutter v. Bollinger. The nonprofit group Students for Fair Admissions sued Harvard and the University of North Carolina, alleging these schools' admission processes discriminate against Asian Americans. The case is set to be argued on October 31st, which will determine the future of affirmative action in higher education. Staying in North Carolina, Moore v. Harper is another important case set to be argued in the upcoming term. This case involves a map drawn by North Carolina's conservative legislature, which was rejected by the state's Supreme Court for partisan gerrymandering. Now, if the court sides with the map in question, that would grant states more power over federal elections.
One other important case comes out in Colorado with a web designer fighting for free speech. Lori Smith says she should not be forced to create websites for same-sex marriages under state law, which prohibits businesses from discriminating against people based on sexuality. The justices will decide whether applying a law to get an artist to speak or stay silent violates the free speech clause of the First Amendment. The decision has the potential to enable business owners to discriminate against marginalized groups based on their beliefs.
So, what exactly does the future hold for the Supreme Court? For an institution as historic and significant as the Supreme Court of the United States, beliefs on where it's heading are bound to be unique. Many of the individuals interviewed for this broadcast feel that the Supreme Court does have a place in American society.
I shudder to think of the way in which, if we lacked a federal judiciary and a Supreme Court, minoritarian rights would be trampled by majoritarian masses, and executive power grabs would go unchecked. And so I think that the body of the Supreme Court utterly imperfect. The design is flawed and imperfect. And the individual justices that we have now are at the very least out of step with my views and values, but also statistically out of step on many issues with the values of the American people. And yet, despite all of that, I still believe that the court is an important component of our democracy.
I think that it has in the past, and I think with the new recent changes on the Supreme Court, it's one of those time will tell kind of things. I'm definitely not, I wouldn't say I'm hopeful that it'll continue to be that way. I think it has been, and especially before this last year, there were a lot of negative decisions for immigrants coming before the Supreme Court that thankfully the Supreme Court did step in to stop some of those things from continuing. But I don't know, especially at least on the immigration side, which is what I tend to focus on, right? Like I do have concerns about whether that will continue to be the case.
At the same time, many feel that the current path is not sustainable.
And as we head into the upcoming term, where exactly the court goes, it's uncertain. But what does come of upcoming hearings surrounding topics like affirmative action, elections, and freedom of speech lies in the hands of 9 justices, including a new Associate Justice in Ketanji Brown Jackson. How will the public react to these decisions? Will they demand change? Will the Supreme Court lose legitimacy among Americans? Or will people be pleased with its direction? Only time will tell what exactly the future holds for the highest court in the land. For WRHU, I'm Ryan Pagano.
I'm Lindsay Hill.
And I'm Michael Richardson. The engineer for tonight's broadcast is also Ryan Pagano. A thank you to everyone involved in making this broadcast possible, and thank you for listening.